Hello, my name is Jim Adcock, and my case study is on Executive Order 13780 by Donald Trump, protecting the nation from terrorist activities by foreign nationals. Executive Order 13780, commonly referred to as Travel Ban 2.0, became a contentious issue when President Trump signed it on March 6th of 2017. The order imposed a 90-day entry restriction on individuals from Iran, Libya, Somalia, Sudan, Syria, and Yemen, and a 120-day restriction on refugees lacking proper visas or travel documents. The underlying intention of the order was to safeguard the nation from potential terrorist threats. However, it immediately generated passionate debate, centering on the precarious balance between addressing national security concerns and preserving civil liberties for immigrants and refugees. Supporters of the executive order claimed that these stringent measures were necessary to protect the nation from potential security risks posed by foreign nationals, specifically from nations with terrorist ties, activities, or actors. They contended that implementing stricter vetting procedures for immigrants and refugees was crucial to ensuring the safety of U.S. citizens. Conversely, critics vehemently opposed the order, perceiving it as an act of religious discrimination and a violation of constitutional principles, particularly the First Amendment, which protects religious freedom. The successive iterations of the order focus on Muslim-majority nations, raised concerns that they unfairly targeted individuals based on their religion, Islam, which goes against the principles of equality and non-discrimination. The debate quickly found its way to the courts, where legal challenges were mounted against the executive order. Several federal judges issued rulings blocking or at least limiting its implementation, citing concerns about its constitutionality and the potential harm it could cause individuals and families affected by the travel restrictions. In response to these legal challenges and public outcry, the administration made multiple revisions to the executive order. The revisions aimed to address the legal concerns raised by the courts while attempting to maintain the order's primary goal of enhancing national security. This revision process highlighted the complexities of creating an equilibrium between the nation's security interests and the protection of individual rights and liberties. As we delve deeper into the case study of Executive Order 13780, we observe the societal impact of these legal battles and the successive versions of the order that arose as a result of the pursuit of finding a tenuous compromise between national security and civil liberties. By understanding this intricate issue, we gain valuable insights into the dynamics of policymaking and its implications on both national and international levels. On November 21st, 2017, a bill was introduced in Congress in an effort to block the ban's implementation. The bill argued that it was discriminatory and harmful to national security. Nevertheless, on June 26th of 2018, the Supreme Court issued a significant ruling upholding a version of the travel ban, which became known as Travel Ban 3.0. The court's decision was a huge victory for executive authority and national security matters. It affirmed the president's right to implement measures by simply saying that his intent was protecting the nation from potential threats. Thus, despite the legal challenges and public debate, The High Court ruling allowed enforcement of Travel Ban 3.0 to continue. President Trump constantly emphasized the need for, quote, extreme vetting, end quote, of immigrants and refugees coming from what he deemed to be high-risk areas. He argued that stricter vetting procedures were crucial to safeguarding U.S. national security and protecting American citizens. Nevertheless, his order faced extensive opposition. They further asserted that it could have adverse effects on national security by promoting animosity and mistrust in the affected communities. However, despite such objections, the Trump administration moved forward with the implementation of the travel ban. On January 31st of 2020, the ban was even further expanded to include citizens from Eritrea, Kyrgyzstan, Myanmar, the former Burma, Nigeria, Sudan, and Tanzania in what was described as, quote, specific cases, close quote. The inclusion of these additional nations generated additional controversy and reignited debate about balancing national security interests and concerns versus discrimination and its impact on global relations. Throughout the very public development of this executive order's successive iterations, it became increasingly obvious that the subject was both complicated and intensely polarizing. The battle between executive branch authority vis-a-vis matters of national security and the protection of civil liberties and equal treatment under the law provoked significant questions about the balance of powers and the role of the judiciary in restraining potential executive excessive liberties. The case of the travel ban presents a compelling study and begs to understand the intersection of politics, national security, and individual rights. It serves as a critical perspective of the challenges faced between policymakers and the judiciary and juxtaposes issues of immigration, terrorism, and the preservation of constitutional principles in a constantly changing global landscape. The case exposes the intricacies of executive authority and the precarious balance between security and liberty in our democratic society. The thesis of this paper is Executive Order 13780, analyzing the Trump administration's inherent discrimination under the color of law. This term is used to describe the abuse of power under the guise of state authority, which is illegal. This academic case study paper aims to explore the highly controversial Executive Order 13780, signed during the Trump administration, which imposed the travel ban on individuals from several Muslim-majority nations and on refugees from these nations. The thesis statement contends that this executive order exemplifies what critics perceive as brazen discrimination under the guise of a legal authority. Through a comprehensive analysis of the order's provisions, its many legal challenges, and the successive revisions, this case study seeks to illuminate the complications of balancing national security with constitutional principles, including equal protection and non-discrimination, by examining the historical context, legal interpretations, and broader social implications of the executive order to provide a clearer understanding of the challenges and ongoing controversies surrounding executive actions in matters of immigration. The global perspective on Trump's Muslim ban was highly polarizing and contentious. It elicited intense reactions from various nations and international communities. The ban faced widespread criticism and condemnation from many nations, international organizations, human rights groups, and leaders worldwide. Critics worldwide viewed the ban as clearly discriminatory and Islamophobic, arguing that it unlawfully targeted people based on their religion. They held that the ban violated the principles of religious freedom and equality enshrined in international human rights conventions and in the United States Constitution. Protests erupted not just in the United States, but across the globe. President Trump's administration implemented immigration bans as a key campaign promise, capitalizing on powers granted by the Immigration and Nationality Act. The initial executive order issued on January 27th of 17 resulted in a complete shutdown of individuals from Muslim-majority nations entering the United States, which sparked nationwide protests and created massive confusion at airports. The rarity of terrorist threats or attacks since 9/11 notwithstanding, legal immigration barriers have remained persistently restrictive. The post-September 11th heightened focus on terrorism provided justification for imposing further limitations on legal immigration regardless of the infrequency of threat events, and none remotely comparable to the scale of the September 11th attacks. This case study examined the implications of these immigration policies on national security, civil liberties, and the discourse centered on immigration policy during the Trump administration. Trump's caustic rhetoric further intensified the controversy as he advocated for measures such as closing mosques and implementing a ban on specifically Muslim immigration, equating Muslims with potential terrorists. His introduction of extreme vetting procedures subsequently led to a significant decline in immigrant, refugee, and visitor entrances to the United States. This decline impacted not only hopeful immigrants, but also desperate refugees fleeing persecution, who now face sharply increased challenges in seeking asylum in the United States. In conclusion, the factual, if not scholarly evidence presented in this paper reveals a disconcerting pattern of Arabs and Muslims, both citizens and non-citizens, being disproportionately targeted by national security policies in the post-September 11th era. Such targeting has resulted in a progressive erosion of civil liberties and a remarkable consolidation of presidential power. In spite of the implementation of such programs over 2 decades, there has been a conspicuous non-existence of accountability, leaving affected communities vulnerable to further discrimination and rights violations. There is, however, a sign of hope. On January 20th of 2021, President Biden took a significant step towards rectifying, or at least mitigating, these issues by revoking Executive Order 13780 and its various related proclamations. The president cited the contradiction to American values, such as religious freedom and tolerance, as well as the undermining of national security in his decision to repeal the order. This revocation was further justified by revelations of Trump's motives for issuing the order, exposing the element of discrimination that was at play and highlighting the lack of factual evidence supporting its effectiveness. Moving ahead, it is imperative that future presidents be held accountable and prevented from utilizing xenophobia, intolerance, bias, and prejudice in the formulation of national security or immigration policies. The government must remain vigilant in perpetuating the principles of fairness, justice, and equality for all, guaranteeing that innocent individuals from foreign nations are not victimized or have their rights violated, just as they would be protected if they were American citizens. To accomplish this goal, ongoing scholarly research and public awareness are crucial in revealing discriminatory practices and seeking consequences. Academia must play a pivotal role in enlightening policymakers and the public as to the importance of safeguarding civil liberties, while simultaneously effectively addressing national security concerns in pursuit of a more just and inclusive society. It is incumbent upon citizens, institutions, and lawmakers to remain vigilant and advocate for policies that uphold the principles enshrined in the Constitution. By collective efforts and a firm commitment to justice, we can rebuild a nation that respects the rights and the dignity of all, notwithstanding their ethnic background, country of origin, or religious beliefs. Determining the precise impact of the Muslim ban/travel ban is complex, and it involves multiple factors. Official data on its specific effects are not available, and studies analyzing its impact have yielded varying results, typically paralleling the beliefs of the authors. Moreover, inasmuch as the ban underwent several iterations and legal challenges, its evaluation became exponentially more complicated. Statistically, it is, in fact, impossible.